Good morning, everybody. It is the Tuesday, March 21st edition of Your House Commerce Committee. We have enough in our places with bright, shiny faces, so we will begin. Mr. Clerk, will you call the roll, please?
Representatives Alexander, Barrett, Boyd, Burkhart, Camper, Clemens, Faison, Freeman, Garrett, Hale, Hardaway, Haston, Hazelwood, Holsclaw, Johnson, Lynn, Marsh, Moon, Powers, Sparks, Thompson, Towns, Vital, Williams, Zachary, Vice Chairman Bricken, Chairman Vaughn.
Here.
Mr. Chairman, you have a quorum.
Outstanding. We're going to do things a little bit differently today. We've got a heavy committee load of bills, but then we're going to jump around our calendar today so that we can get our fellow members in and out that are visiting with us, and then the rest of us will work hours from their seats. So what I'm going to do is I'm going to jump up on the calendar to number 3, House Bill 406 by Chairman Reed.
Thank you, Mr. Chairman, and I do have an amendment to add on at this time.
Motion on the
You want the
subject.
number first?
We got a motion second on the amendment. I hope that's Amendment 4612.
We do have 4612, but do you also see a 5567?
You know, I do happen to see 5567. So 5567 is the one we're attaching now. All those in favor, please signify by saying aye. Any opposed, no. We're hearing your bill as amended.
And of course, this come from Senator Wally. There was some situations, elderly folks in our community receiving these statements and wondering what the fees or charges were being for. But I'll read a summary of the bill as amended. It requires a financing company doing business in this state to provide on its mailed or emailed statements to a consumer a conspicuously displayed telephone number that a consumer may contact for services establishes a violation of such an unfair or deceptive act or practice under the Consumer Protection Act of 1977. Any questions?
There we have it. Anyone have any questions for the bill sponsor? If y'all could stand by one moment, I'm receiving high-level consultation. You did not want the subcommittee amendment attached, did you?
From what I understand, there's two. I want to say yes on 4612 and yes on 5567.
All righty, we understand one was a clerical correction, so we need both of these amendments attached for the bill to do what the bill sponsor would like. So do I hear a motion on,
5612.
well, 4612,
4612.
and we've already attached 5567. So that will put us in the right posture.
Yes, Mr. Chairman.
So all those in favor of attaching Amendment 4612, please signify by saying aye. Any opposed, no. That one's attached. Do I hear any discussion on the bill? Seeing none, we are going to vote to approve House Bill 406. All those in, wait, Leader Camper. Leader Camper has a timely filed amendment. We do. I did not, but we do qualifies us. So I now have it, Leader Camper. Let's discuss Amendment 2. I believe the drafting code would be 5539.
Yes, Mr. Chairman.
All right. Could you explain what your amendment does, please? ma'am?
Thank you, Mr. Chairman. Mr. Chairman and members, what this amendment was seeking to do was to exclude companies that were just digital in nature, something like Cash App or United One, institutions that don't, really send hard copy statements. And so talking with the Chairman, he assures me that this bill don't really address or go into um, detail or does not affect these businesses
That's
that's
correct.
functioning that way. So, Mr. Chairman, for the record, um, would you reiterate our conversation about these businesses being excluded already with this bill?
Sponsor.
Thank you, Mr. Chairman. And Leader Camper, that is correct. This bill has nothing to do with those entities that you just spoke of.
So with that, Mr. Chairman, I'm going to withdraw the amendment because I think we've resolved the issue for the record that these businesses are not included in this bill.
All righty. Thank you, Leader
Thank you,
Camper.
Mr. Chairman.
So House Amendment 5539 is withdrawn without exception. All right, here we go. Now we're going to vote on Representative Reedy's bill. All those in favor, please signify by saying aye. Any opposed? No? Hearing none? The ayes have it, and you, sir, are off to calendar and rules.
Thank you, Chairman and Committee.
We're going to again pick our way through this. We're going back to Representative Gant, House Bill 396. We got a motion and a second. I believe you're also traveling with an amendment.
Thank you, Mr. Chairman. Committee, that's correct. Yes.
All righty. You want to attach the amendment and then discuss the bill in toto?
Yes, please.
All right. All those who want to attach House Bill 5172, Amendment 5172 to House Bill 396, please signify by saying aye. Any opposed? No. You are amended, sir. Please share the great things that this piece of legislation is going to do for the state of Tennessee.
Thank you, Mr. Chairman. And while I've got the chance publicly, I want to praise our chairman here. Going back to when I had my accident back in October, there was a very friendly face that showed up at the hospital that night and was greeting my family and others as they didn't know my condition. But Chairman Vaughn, and I think, matter of fact, his wife was there as well that night. So I want to say thank you to him publicly for sometimes you don't know how much things mean until you actually go through something like that and you see somebody there standing with your family and supporting you during that moment. So thank you, Chairman, for that kindness, you and your wife. So
This bill's looking better by the minute.
Chairman of Committee, what this bill does, this was brought to me and Senator Wally by a couple of ladies in our district that lost their husbands in an accident that was on the job. And this is called the Garrison Jordan Survivor Benefits Act, which is the amendment changing the name as we just put the amendment on. What this does, and I'll be brief, it increases the maximum weekly workers' compensation death benefit to a surviving spouse with no dependent child or one dependent orphan from 50% to 66.67% of the employee's average weekly wage. The big thing it does is it removes the remarriage as a terminating event regarding workers' compensation death benefits, thereby entitling the surviving spouse to one lump sum payment equal to 100 weeks based on the 25% of the average weekly wages of the deceased employee, subject to the maximum total benefit. Mr. Chairman, I'll be glad to try to answer any questions.
Do we have any questions for Bill's sponsor? This is one of those feel-good bills if somebody's struck with tragedy. No need, they need to be, no need for them to be financially penalized just because they find another mate later in life. And I think this is a good piece of policy. It's one that if you stop and think about it, it's the right thing to do. Seeing no questions for the sponsor, let's vote on amended House Bill 396. Please, all those in favor, please signify by saying aye. Any opposed? No. You're off to calendar rules, and Representative Gant, don't scare us anymore. But
Don't
feel
plan
free to come back and shower the chairman with compliments at any time you get a chance.
All right. Thank you, Chairman and Committee.
No, we're going to take, I see Representative Martin out there.
Thank you, Mr. Chairman and committee. This legislation allows a one-time antique and unique auto auction at the 4th Annual Chattanooga Motor Car Festival that is scheduled for October the 13th through the 15th of this year. And anyone who sells more than 5 motor vehicles in 1 year is required to be licensed as a motor vehicle dealer through the Tennessee Department of Commerce and Insurance's Motor Vehicle Commission. This legislation exempts participation in the participants in the festival auction from needing a licensure from the MVC. The legislation was written in conjunction with the Tennessee Automotive Association, who are supportive of this annual one-time event. The Motor Vehicle Commission also was involved in the initial drafting of this legislation. And I'd be glad to take any questions.
Thank you, sir. This is the annual Chattanooga Car Show bill we get every year. For those who are unfamiliar, I see Representative Towns has his hand up down there.
Mr. Chairman, thank you. First, personal question. Do you have an antique yourself?
No, sir, I don't.
Shame, 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 shame. I'd love the bill better if you had an antique. I love antiques. Fantastic. You made the comment about being able to sell 5 without a license. Let's say if you were a major personality or just a person, period, that had antiques, you were not in the business. They were your personal cars. You had 10 of them. Do you need a license to sell them then? They're your cars. You're not in the business. You just want to start liquidating as you get older.
Mr. Sponsor.
I do not know the answer to that question. If we need to ask legal, then I don't know the answer, Representative Towns.
We don't have to ask the league. We can find out. We can find out later. But I would think that a citizen shouldn't have to have a license to sell their own stuff. You know, I don't see where there's a need for a citizen to have a license. You know, you've accumulated. Everyone knows you're not in the business, but that's your stuff. You should be able to sell it when you get ready, regardless of the quantity. That's my point with it. Good bill. Good to see the bill. Thank you, sir.
Representative Hardaway.
Thank you, Chairman. Good morning, sponsor. The effective dates on the bill only cover the dates for the festival.
That is correct.
Mr. Chairman, I'm not sure how many festivals of this kind are held, but perhaps you and the sponsor can get together on putting some language in so they wouldn't have to come to us every time they wanted to have this type of festival. So I look forward to that next year. Thank you, Chairman.
Yes, sir. Anyone else? Anyone else for the sponsor? Let's vote this thing. Let's send the Chattanooga Antique Car Show on down the line. Where we're going to go with it, we're going to go to calendar and rules. All those in favor, please signify by saying aye. Any opposed, no. Hearing none, you're off to calendar and rules.
Thank you, Mr. Chairman and committee.
All right, so we're going to jump back up on the calendar to see our good friend, former colleague on this esteemed committee, Representative Powell. House Bill 750.
Thank you, Mr. Chairman. Miss serving on this committee, but always good to be in front of you. There are 2 amendments I was traveling with the bill, sir.
4542 and 4987.
Great.
All righty, we'll put those on individually. All those in favor, or excuse me, got a motion and a second on Amendment 1. All those in favor, please signify by saying aye. Any opposed, no. Amendment 2, do I hear a motion? Hear a second? Got it. All those in favor of Amendment 2, please signify by saying aye. Any opposed, no. You're fully amended.
Thank you, Mr. Chairman. House Bill 750 amends the Tennessee Condo Act to require the Board of Directors for Condo Associations of Tennessee to conduct a reserve study every 5 years. The purpose of this requirement is to inform condo owners of the condition and life expectancy of common elements of the association so they can reserve necessary maintenance and replacement costs and avoid special assessments for such costs. Special assessments for replacement costs unfairly burden condo owners living in the community at the time of the assessment because most often it requires them to pay for costs beyond their period of ownership. As amended, there's a couple key provisions, and I appreciate a couple the members of the subcommittee for working with me on this. It gives a credit for someone that's already conducted a reserve study since January 1st, 2020. it also exempts any board which oversees common elements with less than $10,000 in aggregate value. When the amendment we added exempts single owner condos and any condo whose board is appointed by and are controlled by a developer. And with that, I would ask for your vote.
Do you have any questions of the sponsor? Seeing none. All those in favor of sending House Bill 750 to calendar and rules, please signify by saying aye. Any opposed, no. Hearing none. You're off the calendar and rules.
Thank you, Mr. Chairman.
All right, we're going to go back into the portion of the calendar that has our fellow committee members presenting bills. So we're going to begin with House Bill 774 by Chairman Moon. We got a motion to second, third. Item number four.
Number 4.
Item number 4 on your playlist.
Thank you, Mr. Chairman, and there is an amendment with this bill, 5232.
Yes, sir. We're showing that. Let's get that on and then we'll discuss the bill as amended. Got a motion on the amendment? Got a second? There it is. All those in favor of attaching amendment drafting code 5232 to House Bill 774, please signify by saying aye. Any opposed, no. Hearing none. You're amended.
Thank you, Mr. Chairman. As amended, this bill would add the existing portions of Tennessee law that already prohibits local governments from imposing mandates on private businesses relative to issues such as leave policies, health benefit, wages, and scheduling. This bill adds to those further restricting a local government from imposing mandates relating to the regulation of employee output, hours, employee benefits. Thus, it prevents a patchwork of different mandates that would be across our state. That's basically what the bill does, Mr. Chairman.
All right. Thank you, sir. So this is effectively keeping municipalities out of the relationship between employer and employee. Is that correct?
Municipalities and counties.
And counties. Okay.
Ordinances and resolutions.
All right. Thank you, sir, for clarifying that. Representative Towns, you have a question?
I do. So what we're saying, Mr. Chairman, you explained it, is that your local government or your local municipality, if their city council or county commission pass certain rules or ordinances, this, that, and other, that happens to impact any business, that they are not going to be able to do it. Is that what we're saying?
Mr. Sponsor.
Not necessarily. What precipitated this, in Los Angeles, the council passed an ordinance saying that after someone cleaned 3,500 square feet in a hotel, that they would have to pay double time. This bill only looks at adding restrictions on output, hours, and employee benefits. Say that you have a construction job and city council has a bricklayer on it and they decide that 12-inch block more difficult to handle. So after in a shift, they lay 80 12-inch block, then they're going to go on time and a half. That's a relationship that should exist between the employer and the employee.
Stand by, Representative Towns. I've got a question for the sponsor that I need to get out before I lose it. It's my understanding that this does not affect incentives that local governments may offer to companies. Is that correct?
That language was put in the bill to clarify and make sure that everyone understands that if it's an employee of the municipality or an employee of the county, they can have any restriction or control of that employee as to output. Requirement maybe for an IRA or benefits such as that. They have full control over their employee, but they can't pass an ordinance or a resolution that would impact an employer-employee relationship.
Representative Towns, you still?
No, I lost mine, Mr. Chairman.
Sorry, I'll start jotting mine down. Representative Hardaway, see if you can find. Representative Towns.
I mean, I did lose it for a minute there. It's coming back. It's coming back to me. It's coming back. Now, with that particular bill, okay, the ability to impact this, just say that scenario is one scenario, but if the local city council ordinances that they came out with dealt with just a bottom salary for employees that work within the city, does it impact that in any kind of way, Mr. Chairman?
Sponsor.
The question is, as I understand it, could the council propose a minimum wage for everyone doing business in a certain county or city?
Absolutely.
And this would say no.
So you're saying it's saying that they would not be able to exercise that salary, right?
Mr.
Accord-
Sponsor.
According to the bill as written, they would not be able to pass an ordinance nor a resolution at the county that would set a minimum wage in that jurisdiction. Right now in current law, 50-2, 113, employers and employees alike benefit from consistent and established standards of wage. Existing federal, state law, including but not limited to Federal Fair Labor Standards Act, the Davis-Bacon Act, Monera O'Hara Service Contract Act, Migrant and Seasonal Agricultural Protection Act, Contract Work Hours and Safety Standards, and the Copeland Anti-Kickback Act. There are, and the reason in the bill this is looked at in this way, you have companies that deal in multiple cities, and think about what would be the common sense approach that Chattanooga would put in a mandate that would conflict maybe with what's in Nashville, Davidson County, or Memphis. So the intent is not to have a patchwork of mandates across the state, to be controlled statewide.
Representative Townsend, we got a bunch after you too, sir.
Mr. Chairman, thank you again. So what it really boils down to, look like the bill is dealing with a multitude of things. You're dealing with production. I understand production. In other words, certainly a municipality should not declare the production of your company, how many widgets per hour triggers whether or not you're going to get paid X number of dollars. I mean, yeah, that's logical sense to me. But it also gets into the salary, the kind of just the economic wherewithal they want their citizens to experience within the city in order to generate whatever kind of economic engineering they're trying to make sure that the city achieve. That's another thing. There may be something else in it I'm missing. So it's covering a lot of ground, is what I'm saying. Some I see, some I question, but some I do agree with. Mr. Chairman, thank you. Thank you, sponsor.
Thank you, sir. Representative Hardaway.
Thank you, Chairman, and good morning, sir. I wish I'd had time to talk to you in advance, but Chairman Vaughn asked you a question specifically about whether incentives programs are addressed and whether those are preempted, those same type of preemptions that are within the bill would apply to incentive programs that local governments might put forward in order to promote diversity, et cetera.
Chairman Moon.
Thank you, Mr. Chairman, and thank you for the question. If a business was coming into your jurisdiction and the council or the county commission so desired, in negotiation of incentives, that's a negotiation between your council and your county commission and that business. So you're a part of that contract. The business may decline the incentive to have the freedom, but that's solely a negotiation between those two entities. This does not speak to that, nor does it prohibit that. Does that make sense, sir?
All right.
Representative Hardaway, you got another one?
Yes, sir. And I think you're saying that this does not apply to incentive programs of local government. But my concern is still more broad, that it seems to interfere with the whole purpose of having a local government, and that's to advance the local public interests in ways that the state government may not do, either because they don't have the local experience and are not responsive to the needs and the values and the demands of local voters and the public in general. So for that reason, I can't support the bill. Thank you very much for the clarification. Thank you,
sir.
Chairman.
Thank you, sir. Chairman Clements.
Thank you, Mr. Chairman. And from what I understand, this bill does not allow local government to enact a minimum wage for that locality. Is that correct?
Chairman Moon.
Thank you, Mr. Chairman. That's correct, sir.
Chairman Clements.
Thank you, Mr. Chairman. And so from what I understand, the argument in support of that is you not want a patchwork of regulations from county to county. Is that correct?
That's correct, sir.
Chairman Clements.
Okay, well, then the express language of this bill, it says that local governments are still allowed to regulate or limit the hours a business may operate. Local governments across the state are allowed to issue permits or not issue permits for any number of things to businesses. So the problem with this patchwork argument is that there already exists a patchwork of regulations that are allowed by local governments from county to county across all 95 counties of Tennessee. Each local business, small business, big business institutes, writes business plans to accommodate for each of those permits, requirements, hours of doing business from county to county. So I'm not sure why we're picking out the wages from the regulations that we're not going to allow these counties to do. I mean, wages would seem to me to be the more important of the issues, given the fact that the cost of living in Nashville is very different than the cost of living in, say, Carroll County. So, those wages are necessarily going to be different. The housing costs are necessarily different. So, while I understand that we need to streamline or have simple regulations that are consistent across the state of Tennessee, I think we need to be realistic and, and accommodating for the costs that working families of Tennessee incur when they do want to work in certain communities. And those local governments, it's incumbent upon them to ensure that people can afford to live in that city, that they can contribute to the local economy, that they can invest in other small businesses and be patrons of other small businesses. So it's a concerning argument, and I just, if you don't mind, could you address the inconsistency there in that patchwork argument that I've raised?
Chairman Moon.
Thank you, Mr. Chairman. The situation about a wage in different jurisdictions, the marketplace should sort that out in our society. Those who pay for labor will set the rate subject to the federal and state laws already in place. And I believe the regulation of the hours, I think that was struck in the amendment, if I'm not correct, that was taken out because it really wasn't germane to the limiting of output, wages, and benefits that are spoken to as the added prohibition. Thank you, Mr. Chairman.
Thank you, sir. You got any more, Chairman Clemens, or we got others with their hands up?
I'll forego. Thank you, Mr. Chairman.
Okay, thank you. Representative Thompson.
Thank you, Mr. Chairman. So just wanted to understand if a city or a county is contracting with a private company for, for services rendered, can they specify to in a bid process that they must pay a certain rate? In other words, yeah, just pay a certain rate or offer a certain level of benefits.
Chairman Moon.
Thank you, Mr. Chairman. In section two, in this section of this bill, that is also prohibited, saying that, okay, the bidders must all have defined contribution pension plans for their employees to be considered as a bidder. That is not allowed under this bill.
Representative Thompson.
Okay, so, I mean, let's say taking out on a bid, they're requiring $10 per hour minimum, whereas some companies might prefer to normally pay $8 for the same levels of employee to provide that service. Is that not allowed?
Chairman Moon.
That's correct. It's not allowed. They have to still follow, all employers have to follow the federal and state laws that are in effect as to labor wages.
I have a question for you, Chairman Moon. Does that mean that could a city require a Davis-Bacon wage scale, or are we just not getting involved with how much folks pay their employees through this bill?
That's correct, Mr. Chairman. We're not getting involved. If it's required by law because of the contract to be let, then they fall within the Davis-Bacon Act, then they have to pay that rate.
And the premise is that the relationship between the employer and the employee is established by the market itself.
That is correct, Mr.
All right.
Chairman.
Thank you, sir. Representative Thompson,
Oh, yeah, thank you for asking part of my next question, Mr. Chairman. So anyway, essentially, the only requirement is $7.25 minimum wage by the federal government. Is that correct?
Chairman Moon.
That's correct, sir.
Okay, thank you.
Thank you, Mr. Chairman. Mr. Chairman, how would this affect existing ordinances? Like in Memphis, we have livable wages. And a couple years back, we passed a Brownfield Act to try to encourage businesses to come in and revitalize those areas, and that they would pay this livable wage to local people in that community. Would this affect our ability to do that?
Chairman Moon.
Leader Camper, we can't pass any retrospective law. And that is an incentive that was put out to bring business to Shelby County. And that would be an agreement again between Shelby County or the city of Memphis to an employer that might want to take that incentive and therefore agree to those terms.
Leader Camper.
And you started out to say that we can't retrospectively affect ordinances that's already on the books. So if we already have a livable wage that stays where it is right now, and this bill would only affect going forward.
Chairman Moon.
Yes, Mr. Chairman, thank you. Could we go out of session and have legal speak to passing a law that would undo something that's already in law?
That sounds like a fine idea.
Levin Middleton, Office of Legal Services. Generally speaking, we can't pass laws that apply to things that have already gone into effect, particularly if there's a contract involved. So to that extent, this wouldn't affect it. There is language in the bill, apologies. In Section 3, Subdivision A, it states, unless required by state or federal law, all additional wage or employment benefit mandates imposed on private employers by a local government are hereby preempted. So that language is in the bill, but again, to the extent that there is already a contract or something to that effect that is currently ongoing, we aren't permitted to pass laws that would affect those.
Anyone have any additional question for our legal counsel, our esteemed, highly qualified, very intelligent legal counsel? Representative Hardaway.
Thank you, Chairman. Council, I didn't hear you mention the Davis-Bacon Act. These exemptions, because Davis-Bacon is federal, these exemptions in no way, shape, or form would impact any of the bidding process or the actual contractual relationships there, would it?
Council?
So if the situations that you're bringing up are covered under federal law would preempt state law to that extent. So beyond that, I would have to look at the actual language in that act. I'm not familiar with it.
All right, thank you, ma'am.
All righty, if we don't have any more questions for council, we're going to go back into session. All right, we have anybody else? Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. And, I think this is the Commerce Committee, and several of us on this committee are in business. And I like your bill. I think what you're saying is we want to keep government out of our business. And if we're not competitive, we're not going to have workers. So we've got to be competitive. We've got to be smart to run our business, to make a profit, or we will go out of business. So I think you've got a great bill. Thanks for bringing it.
Thank you, sir. Anybody else? Seeing no other hands, we are going to vote on Chairman Moon's House Bill 774 as amended. All those in favor, please signify by saying aye. Aye. All opposed? All right, I believe those ayes have it. Noes, please register with the clerk.
Thank you, Mr. Chairman.
All right, we are now heading to House Bill. We're going to go to House Bill 921 by Speaker Marsh. Speaker Marsh, you're recognized.
Thank you. And I do have an amendment. It's 5865, where we had 2 or 3 amendments rolled into one.
That's what we're showing. Let's get that thing attached. All of those in favor of attaching Amendment 1, please signify by saying aye. Any opposed, no. You're in proper posture, sir. Tell us what we're doing here.
Thank you, Mr. Chairman. This bill is brought by the Tennessee Municipal Electric Power Association, and it's increased municipal electric manager purchasing limit. This increases the maximum amount in state law the manager of a municipal or county electric system or energy authority can purchase without board approval from $50,000 to $100,000. Local utility boards and city councils still have to take action to increase the amount for their individual electric systems, which some municipal electric currently have limits below $50,000. This applies to increase to water, wastewater, or natural gas systems if they are under the same manager and utility board as the electric system. So it's the same policy as for the entire utility and organization. With that, I'll answer any questions.
All right, any questions for the speaker? Seeing none at this time, we're going to vote on House Bill 921. All those in favor, please signify by saying aye.
Aye.
Any opposed, no. The ayes have it. 921 heads to Finance, Ways and Means, sir. All right, just for housekeeping, Representative Freeman has requested a roll on House Bill 296 for 1 week. It is rolled 1 week. And then we're going to finish out today's calendar. We appreciate your patience as we've been jumping around. We're going to head over to Representative Garrett. House Bill 1185.
Question on it. Are we ready, Mr. Chairman?
I'm not sure of much these days, Representative Garrett. Let's see if we hear any more sporadic commentary from
All right.
Okay.
I do have an amendment with this legislation with House Bill 1185, amendment coded 5009.
Sir, we are in sync. So all those, do I hear a motion on amendment?
Second.
Hear a motion in a second. Let's get that thing attached. All those in favor, please signify by saying aye. Aye. Any opposed, no. Ayes have it. You are attached and amended. Please share with us about, you can make it as brief as you want, Representative Garrett, because this is your annual trust bill. So
That's right. That's right. Thank you, Mr. Chairman. It's the annual trust bill. I believe this is my 5th year carrying this legislation for the Tennessee bankers. They've got a great group of estate planning lawyers, trust lawyers that get together, and I attend some of those meetings. And I also do estate planning in my law practice. The past 7 years in this state, we've gone from trust money under management from 25 billion to 250 billion, and partly because of how we update our legislation in the support of the General Assembly. And so this is what this legislation does. It's long, it's technical. Trust world is born by statute, so it's very particular on what we continue to hit our statutes to update them to reflect the current world. And so that's why people want their monies invested here. So with that, if there are any specific questions, I'll be happy to take those, but otherwise I will renew my motion and ask for your support.
Thank you, sir. Do we have any questions? Leader Camper.
Thank you, Mr. Chairman. Could you give us a few examples of the things that we're changing here? Like a
Representative
couple, just a
Garrett.
couple.
Absolutely. Thank you for that, Leader Camper. Some things that we are clarifying is, again, this kind of gets technical. The beneficiary gets a distribution by mistake. They're required to return that. That's not in the statute. Also, we're clarifying that any beneficiary is not personally responsible for any debts of the trust because they are actually a beneficiary. So they get the money instead of being responsible for whatever obligations the trust might have. And there are several things like that that we're just clarifying in this piece of legislation. Leader Camper, I hope that's sufficient. Otherwise, I can continue.
We get, hey, I think what she's saying is we trust you, bill sponsor.
Thank you, Mr. Chairman.
All right.
Thank you for your question.
Anyone else? Seeing none, we're going to vote on House Bill 1185 as amended. All those in favor, please signify by saying aye.
Aye.
Any opposed, no. The ayes have it. Sir, you are off to calendar and rules.
Thank
And
you, Mr.
then,
Chairman of the committee.
you just stay on the podium there. We've got plenty of work for you to do. Today, House Bill 1182, Representative Garrett. You're recognized, sir.
Thank you, Mr. Chairman.
Motion and a second. We also have an amendment.
I show that amendment code is 5062, Mr. Chairman.
Man, we're in sync one more time. We got a motion on the amendment. Got to say, oh, let's vote that thing then. We're ready to go. All those in favor of putting Amendment 1 on House Bill 1182, please signify by saying aye. Any opposed, no. The ayes have it. We're amended now. 1182 is amended. Mr. Sponsor.
Thank you, Mr. Chairman. 1182 as amended is called the Land Records Integrity Act. And believe it or not, I was surprised to hear this is happening across this nation. And we're hoping to prevent it here in the state of Tennessee, where a company can have a listing agreement with a particular individual, and that listing agreement can last forever. And as part of that listing agreement, they will have a memorandum that will operate as a lien against the property. So these bad actors will file that memorandum, not the listing agreement, in the Registered of Deeds office, which will act as a lien against folks' property. And if you have a grandmother or someone that's susceptible, this is happening quite a bit in Florida, they don't realize that. So when they pass away or whatnot, when they open up their estate to probate, they've got a lien against their property for a listing agreement that they never did do. So it clouds title. So that clears this up. It's been agreed to by all stakeholders, with the realtors, with the land title folks, to make sure that a service agreement of that nature cannot be recorded. If it is recorded, there's a fine, and I believe it invokes the Tennessee Consumer Protection Act, so it makes that lien unenforceable. So with that, Mr. Chairman, I'll be happy to take and answer any questions.
Thank you, sir. Being a real estate broker myself, I think this is a fine piece of legislation. Anybody have any questions? Seeing none, we're going to vote on House Bill 1180. I did not see Representative Hardaway. And when you see what is between us right here, sir, but it's okay. Myself having a sizable noggin, I can appreciate it. All right, Representative Hardaway.
Thank you, Mr. Chairman. Quite simply, I understand after taking a look. About a question on the obstruction. Okay.
Did you forget your question?
Mr. Sponsor, on the statutory damages, when you talk about actual and punitive, how does all that mesh with the language of your bill?
Mr. Sponsor.
And I'm talking about the $10,000 statutory damages cited.
I'm just referring to the legislation, Mr. Chairman. Give me one moment.
Mr. Chairman, I can have that discussion off grid. Thank you.
Okay, all right. Thank you, sir. We appreciate that, Representative Hardaway. Well, he's got the answer for you right now. Representative Garrett.
It's, Representative Hart, it's enforceable by the Attorney General by disclosure that this took place for that particular fine.
Representative Hardaway.
So we're not creating a new section of the law. We're bringing the processes and the resources from the AG's Consumer Protection Act to bear.
I believe that is indeed the case,
All right.
Representative Hardaway.
Thank you.
All right, let's vote unless anybody's got an objection, let's vote on House Bill 1182. All those in favor, please signify by saying aye. All opposed? Hearing none. 1182 moves to calendar and rules.
Thank you, Mr. Chairman and committee.
I know that everyone at this point is just tingling with excitement. We have placed Chairman Boyd at the end just to tease you with that. It's kind of like while they put the 5-day forecast at the end of the weather segment because they know really that's all you wanted to see anyway. So Chairman Boyd, we're going to recognize you on House Bill 1211. And we have a motion and a second. And I believe you've got an amendment, Chairman Boyd.
Thank you, Mr. Chairman. I'm showing Amendment Drafting Code 6138.
That is what we've got. I got a motion and a second on that. Let's attach that and then begin our discussions. All those in favor of placing House Amendment 1, which is coded 6138 on House Bill 1211, please signify by saying aye. Any opposed? No. You're amended. Share with us, Chairman Boyd.
Thank you, Mr. Chairman of the committee. So members, as you know, all the way back in the Haslam administration, the state started allocating funds for broadband deployment across the state of Tennessee. And that number has gone up each year, and we've continued to fund broadband expansion, and the federal government has been involved at multiple times. And we have got nearly $1 billion in BEAD money that's going to be flowing from the federal government through ECD coming up here pretty soon. And that's the Broadband Equity Access Development money that's coming down. And so what this bill does is it creates some legislative guardrails. We want to make sure that these dollars go to the unserved Tennesseans so that we don't go in and overbuild areas that already have high-speed internet. We also want to make sure that entities that have already received public dollars for broadband expansion do not receive money a second time for the same area. We want to make sure that the broadband that is installed is at least 100 megabit download with 20 megabit upload speeds. We have an emphasis on last mile projects rather than middle mile projects, which we've seen our neighbors to the north in Wildcat country up there. They had some problems with the middle mile coverage. And so although some of this money can be used for that, we want to make sure that it's last mile coverage. It also puts language in there that provides direction to ECD that the cost of a proposed project can be a key factor. It will not be the only factor, but it will be important. So if a provider can expand in an area at a lower cost than a competitor, that will be heavily weighed. It also ensures that the internet providers put some skin in the game by providing matching dollars to receive the grant. It will give a greater weight for those that can provide a higher match. It provides that a report is provided each year by to the General Assembly and to the to the legislature, and so it ensures that. Let's see here. I'm trying to hit the high points here. It requires that that ECD maintain a list, a database of those that are unserved, and it is plugged into the broadband accessibility map, which is a pretty good idea, and it does a good illustration of who has broadband and who doesn't. And it ensures that if they do not use the money to do the project in a timely manner, there is a clawback provision, a 20% clawback provision. Mr. Chairman, I would doubt with that thorough of an explanation that anyone would have any questions. But if they do, I'll certainly answer them.
Mr. Chairman, I agree with that. However, I just want to demonstrate my understanding of the subject matter by engaging you in a little bit of a conversation here. And actually, it's something that one of our fellow committee members and I had a conversation about with regards to the equity being considered with regards to a grant. That's how much that a provider is going to be, they're going to be dedicating or they're going to be providing for that grant project. It does not have to do with the market capitalization of the company itself, or that's what I'm asking, because if that's the case, then much of your publicly held companies would score a lot higher in that versus some of your smaller co-ops and munis. So that's the question is with this scoring where equity is being considered with regards to where it comes into the evaluation, is that overall market cap or is that what they're dedicating to that particular grant?
Mr. Chairman, my understanding of it is the amount that they're putting toward that particular project. It's not the financial sheet of the company. It's more a matter of how much money they're willing to put in, how much skin they're willing to put in the game.
All right. Thank you, sir. That was our understanding as well. We have Representative Towns.
Mr. Chairman, thank you. As well, sponsor the bill. Couple of questions. When you're determining exactly, well, first, obviously we need broadband throughout our state, everywhere. It's just necessary. There's no question about it. And we should want to try to expedite that as quickly as we can. So for that, we're grateful that we have money that will actually target those areas. However, as I think about it, rural areas are absolutely probably under funded, and as well as they don't have the broadband. Would you agree with that, Mr. Sponsor?
Thank you, Mr. Chairman. I would agree with that. It's largely the rural areas at this point that have not been served.
Absolutely, and they're behind. However, what we want to do is also in your urban areas, and what's on the record, you don't want to forget that there are pockets in the urban areas that have been underserved as well. And those pockets prevent young kids from doing their homework, obviously whatever is necessary on to be on the grid, finding jobs, applying, and doing whatever creative stuff you need to do. So when they're developing that list, ECD, they need to be in total looking at everything, certainly the rural areas. We all know that needs to be addressed. But in these urban areas, I can't call them, and most of them, but there are pockets that need to be served because that city itself may be doing well, and it may not be doing well in the total area. So I want that on the record, that they need to make sure that they look at those areas where you have urban areas that have pockets that need to be developed as well.
Thank you, Representative Towns. I will have to say that with regards to resources that are available showing these areas where broadband has been successfully deployed in areas that we still need it, ECD both has a map as well as the federal government that are pretty detailed when it comes down to the areas showing that are underserved or not served at all. And so I know that's a tool that our folks rely on tremendously. We're going to head over to Representative Alexander.
Thank you, Chairman, and thank you for your question to the sponsor, and thank you, sponsor, for this bill. I know we need accountability, but broadband no longer is a luxury. Just a few years ago, we thought it was. It's not now. It's a necessity. And I think that we do need this accountability, but at the same time, another year has gone by. We had some bills last year on the table. I, for one, had one that would help get broadband to my constituents. We've all got that issue. And I think we decided to lay ours on the table in lieu of the maps coming out. A year has gone by. We've seen the maps. They've told us no surprises. We know we've got some real issues out here. And my hope is that this state will take a real seriously look at how to get this done. I mean, accountability is great and we need that. but we need to let all the players have a seat at the table and get this job done. Because what works in my county and my municipality that does a tremendous job in my county doesn't work in Representative Sparks's county. It's all different, and we need to take a look at these maps and let's get the job done. Thank you very much.
Thank you, Representative Sparks. Your name was called?
I'll just give a plug out to United Communication, Comcast. They're doing great work back in Smyrna, Tennessee. Thank you.
All right, thank you. Representative Zachary.
Thank you, Mr. Chairman. Just similar comments to Representative Alexander. I think it's extremely important for this committee and the Finance Committee, because we probably see ECD more than others, to bring a level of accountability. This is a good piece of legislation. I do support it. It does provide some guardrails and parameters that we haven't had in the past. But it's important to remember we've been having a very similar conversation since 2017, and we continue to talk about unserved versus underserved. And so while I'm not crazy about the definition that is in the bill, because I know that matches up with what the feds are doing, related to those communities with 100 meg or less being unserved, I think many of us would see that as underserved. I still think it's just extremely important. I've talked to Commissioner McWhorter about this, that we bring a level of accountability and oversight as we walk through this to ensure that our unserved communities are actually served through this $1 billion, or we'll continue to have this conversation 2 years from now. Again, we started this process in 2017, and we were told initially that it'd take about $500 million to cover the state. And here we are, another $1 billion in, saying, actually, this will do it. So if we're going to address our unserved communities, those who do not have service, then let's get the job done and address the communities that do not have service before we worry about addressing those who don't have just quite enough bandwidth to allow 15 teenagers to stream and watch at their house. So thank you, Mr. Chairman.
Thank you, sir. Vice Chairman Brickens.
Thank you, Mr. Chairman. And I will say, when this legislation gets passed, I just would like to get maybe some talking points to take back to my district. So if ECD is going to administer this, is there a timeline of requirement to be sure those grants get put out? And then do the grants specify to the vendors or companies that receive the grant a timeline to implement the broadband service?
Chairman Boyd.
Thank you, Mr. Chairman. And members, I mentioned this in subcommittee, and I'll mention it again now. So I'm not creating the BEADS ECD grant program here. This is just some guardrails that we're superimposing on there to tighten them up a little bit. If y'all would like to learn more about the BEADS program, we could probably get a presentation in front of this committee so y'all could ask questions on that. I'm not inventing that. These are just guardrails in place. But so as far as the timeline on the BEADS money coming down and how much time is written into federal statute that requires that it be administered within a certain period of time, I don't have all that data with me today. And I also want to emphasize that in this bill, we have language that essentially says that if there's any sort of disagreement in the language of this bill and the language of the federal BEADS program, that the BEADS program will trump what we have going on in this bill. So,
thanks, sir. Representative Hardaway.
Thank you, Mr. Chairman. First, I want to express my appreciation to President Biden and his administration for these dollars and the program itself. But I want to speak also to Chair Lady Alexander's concerns. And I want to make sure that we understand that when you don't have adequate bandwidth or speed, that some apps, some platforms are not accessible to you. It's not a matter of whether it's going to take you longer and there's going to be a lot of buffering. You can't access some of the things online without high speed. So I want to make sure our members understand that point. And I would also suggest, Mr. Chairman, that the committee may entertain keeping more oversight on this program as it goes forward. Number one, requiring a regular reporting period where we can keep up with what's actually being done, how the funds are being dispersed, how the construction, how the allocations are being made, et cetera. So those are the things that I wanted to make sure that the committee understood. But when you're talking about competition between high speed and the low speed, it's kind of like getting dial-up. Nobody can work with dial-up these days, and that's what's happening now. With more bandwidth and higher speeds, it makes some programs unaccessible, some services unaccessible to those who don't have that bandwidth and speed available to them. Thank you, sir.
Thank you, sir. One thing that people say never is I really miss AOL. Representative Vital.
Thank you, Mr. Chairman. And I just want to say to the chairman of the committee, I appreciate him bringing this and keeping the momentum moving forward. I think we all know that broadband is one of the most needed aspects across the state. And in even our most urban counties, some of us have some of the highest speed internet in Chattanooga in parts of our county, but at the same time, other parts have no internet. And I think we have to remember that it's just not rural. There's real disparity in our service areas, even within the urban counties. So I encourage this and help us move aggressively, even in the metropolitan urban areas where we have no internet. Thank you.
I've heard the question. The one thing that I will say, though, before we call the question on the bill, you weren't recognized, sir, is that if Representative Alexander doesn't get internet to certain segments of her district, I'm going to have to be up there climbing poles, hanging wire, because she is relentless in her pursuit of internet. Without objection, let's vote on this fine piece of legislation. All those in favor of House Bill 1211, please signify by saying aye. All those opposed, hearing none, 1211 is off to Calderon Rules. And then, as our big finale today, once again, Chairman Boyd coming back with House Bill 947. I got a motion. I've got a second. All right, so House, you've got an amendment, sir. I believe it's House Bill or Amendment Code 5317.
Thank you, Mr. Chairman. That is what I'm showing.
Do we have a motion on that amendment? Motion second. Let's attach the amendment. All those in favor, please signify by saying aye. Aye. Any opposed, no. You're in proper posture, sir. Please tell us about 947.
Thank you, Mr. Chairman and committee members. If you were a part of this committee in the previous General Assembly, you were with us when we had the presentations and the breakdown of all things utility in Tennessee. We learned about public utility districts, water authorities, municipal, electrical co-ops. We learned about investor-owned utilities. And one of the things when we got over into the public utility world and looked at the oversight that the Comptroller's Office has, we learned that there are two boards very similar, the UMRB, which is the Utility Management Review Board, and the Water and Wastewater Financing Board. And they had almost identical duties and regulatory authority. And so one of the things that we asked our comptroller was, wouldn't it make sense to just combine those into one board? He agreed. This is the result of that merging. These two boards will be merged together to create the Tennessee Board of Utility Regulation, or TBOR. Mr. Chairman, I'll take any questions.
Thank you, sir. Sounds like a little bit of streamlining going on to me. Chairman Clemens, is that the way you see it?
Of course, Mr. Chairman. Thank you, Mr. Chairman. Representative Boyd, it appears here that there's an intent to have multiple knowledgeable, competent people appointed to this. Is that correct?
Chairman?
Thank you, Mr. Chairman. Absolutely. So the two previous boards each had 9 members. In the new combined board, there will be 11 members, and they are highly competent, Mr. Chairman.
Chairman Clemens.
Thank you, Mr. Chairman. Well, how come the chairman of the Commerce Committee doesn't have an appointment on this board?
That's that's a very astute question. I'll have to give my friend the.
Thank you, Mr. Chairman.
Representative Hardaway.
Thank you, Mr. Chairman. And this question is more to you. How does this bill impact MLG&W operations or organizational structure?
What will happen, Representative Hardaway, as opposed to them reporting to one of the two previous boards, they will now report to this single board. They still have reporting requirements. It'll just be from opposed to the old board to the new board, but they're doing the same thing.
So are there any penalties or new directives besides the reporting requirements? Are we trying to get into the operations of MLG&W?
No, sir, that's not the intent of this bill, nor does the words in the bill indicate such.
That's good news, sir. A bill that doesn't go after Memphis and Shelby County. I'm proud of the committee work. Thank you.
Thank you, sir. Seeing no other questions, let's vote on House Bill 947. All those in favor, please signify by saying aye. All those opposed, hearing none, the ayes have it. You are off to GovOps. I was so eager to get started today, I didn't ask any of the committee members if they had any personal orders. Anybody have any? Oh, I hate that. So with that, I'll entertain a motion to adjourn. So we're adjourned.